Hi everyone, thanks for joining us today. My name's Julianne. I work here at Master Plumbers and I'm the Senior Partnerships and Membership Coordinator here. We have a really exciting session on for today. Just a couple of notes before I get started and introduce you to everyone. We've enabled the Q&A function, so you'll see there on your screens, you have a little option to ask any questions. That could be both for myself at Master Plumbers or for Ping and her team at Level Playing Field. Feel free to put those in. We'll get to those either at the end or if appropriate, we can answer those throughout the presentation today. Also, just a note, this will be recorded, so we will be able to send through a recording and a copy of the slides as well. So you'll get that in a follow-up email from us tomorrow. Let's get started for today. So today we have two presenters from Level Playing Field. So Level Playing Field have been corporate members of ours now for a couple of years and a really great member, and have been able to do some great podcasts and other educational pieces for us in the past couple of years. And this is definitely a topic as far as legal contracts that we get asked about a lot. So we sort of ask them to come back and do something a bit more tailored for you guys and what you are sort of wanting. So I'll do a short little intro of the team. So we've got Ping, which is the lovely photo here. So Ping is the director and principal lawyer at Level Playing Field. Ping comes to us with great credentials and terrific experience, having worked as both a lawyer and as a builder in the construction industry for over a decade. We also have Boyan here. He has worked in the construction industry for over 15 years as a builder and subcontractor. He deals with issues faced in construction on a daily basis and enjoys sharing his knowledge and experience to help subbies improve their businesses. So together, Boyan and Ping created Level Playing Field Lawyers, which specializes in advising construction subcontractors on a wide range of legal issues, including contracts and the Security of Payment Act and disputes. So I'll ask Ping and Boyan to turn on their screen for us now so that we can see them and say hi. You'll also notice that Tina is there as well. Tina's going to be accessing the Q&A. So as I said, just feel free to send through any questions through there and she'll either reply directly to you or we can round them up and get to them at the end. But for now, I'll hand over to you, Ping. If you just want to share your slides with us now, we can make a start.
Great. I'll just share the, you'll have to stop. Oh, sorry, we'll stop. Yeah, that's fine. Thanks for that introduction, Julianne.
Thank you.
Hopefully you can see our screen properly. Yell out if you can't. Boyan and I work in the construction industry, so we get that there are a lot of payment disputes. And we get that it's very difficult for subbies to negotiate their contracts. But it doesn't mean that you shouldn't understand your contractual risks and you shouldn't negotiate your contracts and also manage them throughout the project. So we're here to give you a breakdown of a typical plumbing subcontract and talk about the issues that drive disputes and how you can avoid those disputes.
We're going to go through a whole bunch of circumstances that we think that are pretty common in industry, especially in the plumbing industry, and give you guys some examples of what we've experienced as well lately, especially. And then, yeah, hopefully you guys get to understand that, you know, having a legal team is also a new requirement, just like you have an accounting team to take care of your taxes. You should have really, if you're getting into contracts, which all of you are, you should have some sort of knowledge in the legal field. And if you're not sure about a lot of stuff, we're happy to have a chat and give us a call. And we're trying to be another part of your team to, you know, as you're growing as well.
Yes. So at the foundation of a construction contract, what is it? It's a risk allocation document. So you go on a construction site and there's a whole bunch of tasks that need to be done. There's a lot of responsibility and there are a lot of risks. For example, who's going to do lagging? Is it going to be the concreter or is it going to be the plumber? There's all these little things that need to be done. Death by a million paper cuts is what we say as builders. So many things to be done. And your contract will actually state who is doing every item on a construction site and who's going to bear the risk when something goes wrong. And from a construction law perspective, the most efficient contract is a contract that it pushes the responsibility to the person who's best able to bear that risk. And a lot of subcontractors don't realize how risky their subcontract is. And the reason why so much responsibility is being pushed down to a subcontractor is because technically they are in the best position to manage those risks. A subcontractor, they're on site doing the work, and apart from that, they're a technical specialist. A builder is a general contractor across supervising all the trades, but the person that has specialist knowledge is the subcontractor. And that's one of the reasons why subcontracts are written to be so onerous, because if something is going to delay a subby, or something, some site condition is going to increase the cost for a subby, the subby is in the best position to manage that risk. And that's why the contracts are written that way. Our firm deals with a lot of disputes in the construction industry. And apart from issues such as business failure and insolvency, the other reason why there are so many disputes in the construction industry is a lack of communication. So there's miscommunication about who is bearing the risk of certain things. There might be an understanding where a subcontractor has said, look, I've quoted for all these items and that's what I'm responsible for. If the builder tells me to do something, I'll do it. And that's what I'm responsible for, and that's it. However, the contract might not be written that way. And so it's important to understand the contract, because that's what you're being, when push comes to shove and a dispute arises, you're being held to your contract. So I'll give you an example of risk allocation. So we were advising a plumbing subcontractor in relation to a payment dispute. And what happened was there was a leak on a leaking pipe, and it was on a quite large scale project, and there was a lot of property damage. So it leaked all over the weekend, and there was a lot of property damage because it was almost being handed over. And so you think about the loss in this situation. There's the cost of fixing the pipe. There's the property damage, getting rid of all that, any plaster that had to be removed, replastering, patching, any carpentry works, all that kind of stuff. Then there's time lost. And the developer, maybe they're charging liquidated damages. And then there's the management costs for the builder. There's all these types of losses, and your contract will allocate who bears that risk. And you might be the best person to bear that risk because you have insurance, or maybe your insurance doesn't cover that. But that's the kind of thing that needs to be considered in a contract, these kinds of risks. And so what do you do about all these contractual risks? You have a few options. One of the options is you can manage the risks. I'll give you some examples. You can price the risks, or you can negotiate the risks. So in relation to managing the risks, you can either insure it, so you can take out insurance that covers the risk, or in the case of, say, liquidated damages, which we'll talk about more further in the presentation, you can manage the risk by issuing extension of time notices. Pricing the risk, that's about considering what is the likelihood that this is going to happen. Is this a basement job? Is there more chance that there's going to be a leak? And if a leak does occur, what is going to be the cost of that leak? And you can price that in. And then the last example I've given is to negotiate that risk. And that's some of the stuff we're talking about today, because I know most subcontractors, the first thing when they get a contract, they don't think, oh, let's try to negotiate these clauses, or they might just look at the scope of works and just cross out a few things that they haven't allowed for, but they won't actively negotiate the general conditions of contract, which is the terms and conditions of that subcontract. But that's exactly what you should be doing. You should be looking at what are the risks for your business, what are the risks for this project, and what do we need to negotiate out of.
So is it better for them to do it right at the start or halfway through, or what do you think is the ultimate time for them to actually look at it?
Yeah, so that's what I find. We help a lot of our clients with doing a contract review. However, we're also about educating subcontractors, because a lot of that has to be done at the beginning. You need, when you're negotiating and you're going to the tender review interviews, you probably need to be raising some of these points. And so we help our clients with preparing a tailored tender review checklist, because that's what you should be doing. You should be having a standard checklist for your business with all the issues that either you've come up with or that you're concerned are going to come up. And then you have a discussion at the tender review interview. And then if the contract is, you think it's quite complex, or it's quite a large sum and you think, I want to get some legal help as well, then that's when we generally get engaged after the tender review interview process and a subcontract has been presented. But definitely you should start the conversation at the tender review interview stage. And so that's the next slide. We'll go into some of the things you should think about at the tender review interview. So being a risk allocation document, you should really take a proactive approach in negotiating and dealing with the tender review interviews, and also in relation to the contract. So don't make assumptions about what the builder has allowed for. Different builders assume that different subcontractors will allow for certain things, but also the builder might not be experienced in this type of construction or in your specific issue. So they might, even if they're doing apartments all the time or they're doing school jobs, what you may encounter, they might not understand to the technical, to the detail that you will understand. And some of the main clauses or issues that we negotiate are things like site conditions. So who's going to bear the responsibility of underground services? Will the builder locate the services and then you have to avoid damaging the services, or are you responsible to locate the services and avoid the services? What happens if the foundations are different to what you anticipate? Maybe you get a soil report, but the soil report's only taking a few boreholes. There might be unexpected things. Who's going to bear that responsibility? Most plumbing subcontracts are written like this. They'll say the subcontractor warrants that they have inspected the site and basically accepts the site conditions as they find them. And they also say that the builder makes no representations as to the site conditions. So they're not making representations that you will be able to access your working area using, I don't know, whatever excavator or crane or truck that you anticipated using. Therefore, you have to either negotiate and say, we accept all site conditions except for these concerns, or you might have an access plan, or you might have exclusions in relation to rock or contaminated soil, those kind of things. Other issues that we come across commonly is that sometimes a plumber may only allow for, they'll look at the structural drawings, they'll look at the civil drawings, the hydraulic drawings, and all the ones that are to do with their works. However, there may be other drawings like landscaping drawings or certain drawings that impact the way that they can build, and therefore they have to change the building methodology, and that can increase the costs. Most plumbing subcontracts are written so that your works are subject to all the drawings on the drawing register. So unless you insert a specific limitation, you're really expected to look through all the drawings in the drawing register and consider how that may impact your work. We're finding that
there's just no point in obviously just pretending like it's not going to happen, which we're starting to see it on site, which is it's not my problem, it's the other guy's problem, or it's the builder's problem to deal with, or he told me to do it that way, and then it's just the way it is. Right?
Yeah, unfortunately, that's not how it's seen legally, and we're seeing on the construction sites, VBA, they are doing audits.
Oh, definitely.
They're doing audits because of, I guess, the heightened awareness in the media about building defects and all the issues that have come up, after a big building boom that we've seen. There's a lot of defects that people now being very concerned about building defects, and the VBA now has to go out and do audits. And we'll talk about a case study later in the presentation in relation to things that may not seem to be an issue, and they can come up 1 year, 2 years after the project has been handed over. So we're seeing a lot of builders pushing down the design and construct risk down to the subcontractors, and they'll include things such as buildability issues. So you have the builder engages consultants, and they've produced all the documents, and then you get on site and you're not able to build as how you've anticipated. And I won't say most, but there are a lot of subcontracts out there where that buildability risk is being borne by the subcontractors. So you should look out for, is there a buildability clause? Is there a design responsibility in my subcontract? Does the scope of work say design, supply, and install? Because that could include buildability issues. And I forgot to say with the previous slide, ways that you can manage that, and we touched on before, was to create a checklist. Create a checklist because there are a lot of things that you may have thought of in one project and you don't transfer it to the next project. So if you can create your own company specific checklist, you can make sure that you cover off on all these risks, and you either negotiate or manage them.
Can they come to us as well?
So yeah, that's something that we help subcontractors do. It can be hard to focus all the risks and all the issues that either you've come across or other people have come across. So we help subcontractors create a comprehensive checklist, which they can use to use in the tender review process or when they're looking at their contracts. So there's definitely something that we advise all subcontractors to do. So subcontractors to plumbers. As a major subcontractor, you may be engaging other subcontractors. So that could include maybe an excavator subcontractor that will do the trenching, or it could be a roof plumber if you're subcontracting out a portion of your plumbing works. And because the subcontract between the builder and you is quite onerous, you should make sure that responsibility is being pushed down to subcontractors below you. So that's known as making sure the risks are back to back. So if you think that you're subcontracting out a portion of the risks, you have to make sure that the terms and conditions that you're trading with the builder also flow on to your subcontractor. So that would be in terms of, you're thinking about things like variations. If one of your subcontractors is issuing a variation to you, you want to make sure that you can also issue a variation up the chain to the builder. It's when you think about things like site conditions, you also want to make sure that whatever site conditions you have to accept, your subcontractor has to accept.
And is that a conversation that they can have during the tender process, or is that something that has to be relayed down to the subcontractor?
Yeah, that's right. It's a bit of a mouthful when you say the subcontractor, but it depends. For the larger projects and the more complex projects, I think that you have to engage in dual negotiation. So you'll be negotiating with the builder as you're negotiating with your subcontractor. And then you're looking through the draft subcontract while you're preparing the draft subcontract. But when you're talking about smaller projects where there probably isn't the time or the budget to ensure that these risks are transferred appropriately, you might accept a contract with the builder and then negotiate with your subcontractor. But you should definitely formalize that into a contract. Otherwise, you're left exposed in a situation where you're legally bound to be responsible for X, Y, Z, and maybe your subcontractor will only do XY. So definitely that's something that should be considered.
So you'll almost be in the same position as you are with the builder. You should be also relaying that contract down or negotiating that contract with your subby as well. So you can understand that you got the clarity between exactly what's supposed to be done, and that has to obviously be relayed down to the workers in your team. Because I'm getting a little bit of this lately, which is this is the way I've always done it, versus no, this is what the contract states, and that usually that communication isn't relayed down to the whole team, and that's something that as the head contractor you have to be responsible for, is relaying information down to the guys.
And I think that the construction industry is becoming more regulated. It's becoming more regulated because of issues that have happened, and then when something happens, people look at, okay, well, who's responsible? And then that's when you get into these legal disputes. If you look at the cladding issues that are happening at the moment, they're saying, how did this happen? And then they're finding who's responsible, and they're trying to tie all that in. So I think there is a lot more focus on less of this handshake agreement. We agreed he would do this and I would do this and it'll all be good. It's a lot. I think the industry's moved to a phase where people, there needs to be certainty. So the builders I think they've always transferred the risk to the subcontractors, but maybe they haven't enforced the contract. The contract's sat at the bottom of the drawer and they haven't really talked about it, but the responsibilities have been there, and now they're being enforced more during payment disputes and also through litigation in relation to defects. And then the subcontractors, the major subcontractors, now have to make sure that it's being transferred down to subcontractors below them. So that's the way the industry is moving.
And that's why you should always take advantage of the legal advice, because the industry is changing for everybody. I know myself as well, when we were I was a subcontractor myself, it was a little bit more straightforward. I maybe didn't have as many, my job wasn't as complex or as risky as some of the jobs that you guys might be taking on. But the way it was done, it's not that anymore. So
it used to be, if the builder tells you to do that and then an issue arises, it's like, oh, well, the builder told me to do that. But that's not accepted these days. No.
And then also prove it that he told you. Was it verbal? Was it written? How was it designed? And then you don't want to get in a scenario where you find out that you've got the shortest straw in that scenario, and you should have got legal advice beforehand before you, or done it by the book. So the book is being rewritten all the time, and that the construction code is always changing, and that's your responsibility as well to find out how it's done. And then it's also responsibility for the builders to follow that code as well, and make sure that the subcontractors are doing that part as well.
Yeah, and just on that point, I would always say if you're being told to do works that you think will result in a defect, the best advice is to try to convince the builder to do the work in accordance with the plumbing standards, or if it's the NCC, that's always the best, to do it as it should be done. But if you're being directed, and the subcontractors are generally written in a way where if you're being directed to do something, you must follow directions. If you're being directed to do something, you should give them a written warning. So even if you tell them on site, I don't think that's a good idea, that's going to result in a plumbing leak, and they say, no, we want you to move ahead, we want you to do that work, then what you should do is make sure that you issue a written warning very clearly stating, it's our professional opinion, we should not do works as ABC. And if we do works as per ABC, it's going to result in this leak, this whatever. Do you still want us to proceed as per your direction? And get that clarified, because if an issue does arise, you'll be able to produce that written warning as evidence that you try to warn the builder not to do it that way, and that you gave them your professional opinion and you discharged your liability, because prima facie, that is a subcontractor's responsibility, because you are the technical specialist. So you need to do work that is going to meet the standards and is not going to result in defects. And unless you discharge the liability, it could come back, and it's not a nice lesson to learn. So, well, moving on just to the next slide. So a lot of subbies ask, so do I need to negotiate all my contracts? Do I need to get a contract review on all my contracts? And what I say to them, it's all about, you have to weigh up the risks and the costs. So, you'd be looking at how risky is your project? How big is the contract sum? And then you can decide, okay, this is how I'm going to negotiate. And there's levels of negotiation. You might negotiate something just to limit the risk, or you might negotiate it to avoid the risk completely. And so some of the things that we consider, some of the considerations for when you should negotiate a plumbing subcontract would be if the project is going to span a long duration of time. I don't know if anyone in the audience has signed up, I'm sure you have, signed up to contracts before COVID, and you're performing the works now. And you'll probably have noticed that your supply items have increased in cost, your cost of labor and availability of labor has changed. So you can see that it doesn't have to be something as crazy as COVID, but things can happen.
Just a boom time.
Yeah, it could just be a boom time, or it could just be everyone decided that this year we're going to go on holidays. I don't know, whatever it is. But the longer your project spans over, the riskier it is. And then the more stages that are involved, it means that there's more chance of delay, and then pushing you into an environment that you didn't anticipate. Almost all subcontracts are written with a no rise and fall clause. A no rise and fall clause means that for the duration of this subcontract, you can't charge extra for supplying materials, even if you face those kind of risks. And once you sign that contract, it doesn't matter if you're directed to do the works 2 years from now. You're signing that contract without limitation. If the subcontract requires you to comply with all regulations, which most plumbing subcontracts do, then even if the drawings, it might not be that the drawings show work that is contrary to the regulations. It might just be the drawings don't show all the details. So then it leaves you with this gray area that you have to make sure you're complying with the regulations, but the drawings don't actually show you what is specifically needed. Some other things, so the authority works, if you're doing authority works, that might increase your risk and also increases the amount of management. So you might want to make sure you limit some of your risk. If the design is, so if you get tender review drawings and you know that there's going to be lots of changes during the project, yes, you might be able to get a variation, but you might end up with a payment dispute because the builder has signed on to a design and construct contract and they can't get a variation. When builders are getting a variation, they're probably quite happy to give you a variation, but if they have to absorb the cost of your variation, you're likely to get there's more chance of you getting a payment dispute. If a builder doesn't traditionally do this type of work and then they go into a different area, you might find that that project becomes more risky because they might not anticipate some of the things that will escalate your costs. And things like existing structure will always increase your costs. So this is another case study. So we were helping a structural steel fabricator with a payment dispute. And basically, they were doing structural steel on a renovation project. So it was a large apartment project in the city, and I think they were gutting a couple of the levels or demolishing a couple of levels and building up from there. And once they started demolishing, they encountered latent conditions. There were a lot of issues that had to be resolved before they could proceed with works. And so this project ended up being delayed for, what was it? I think over a year or more. And the builder the structural steel fabricator didn't have the available resources. So they had in their pipeline the capacity to do it when they signed onto the contract. And then once it got pushed to a certain stage and the builder wasn't they didn't know when they could resolve these issues with the design consultants. So once they resolved the issues, they straight away directed the subcontractors, get back on site, let's continue works. However, the steel fabricator had already filled up his pipeline and they didn't have capacity to proceed. So as soon as you have a project where there's a renovation project where there might be significant latent conditions, then you're thinking about, let's look at the liquidated damages clause. Let's look at the suspension clause. If the builder suspends, will we get a variation? Or do we have to start back on site at a week's notice or something like that? And the variation clauses, will you get an escalation of costs? Let's move on to the next slide.
Now, just you sort of bring up a point about other contractors on site, obviously the steel guys, concreters and everyone else and plumbers. And we just want you guys to understand that you're not isolated. It's not just a problem that you guys are experiencing. We're obviously seeing it across the whole board. And sometimes it might actually be good just to find out who the other contractors are and having the communication with open to them, because you know yourselves that the plumbers, can be, you're affected by the concreters, you're affected by even the plasterers sometimes when there's, doing works and whatever it is. It might be a good idea to have a conversation with them, and so that you're all on the same page, because fundamentally you all work as a group, even though you're sort of separate, but you're dependent on each other to work together, and that sometimes is a little bit overlooked. But it's definitely a good idea to have that conversation with the builder, of course, and then deal with the other subbies as well.
Yeah, I find the builders that really deliver successful projects where everyone makes money and there's no issues. It's when they have those coordination meetings with subcontractors, and they so then everyone knows, okay, well, the plumber's going to be impacted if the concreter does this and those kind of things. So.
And there's always going to be issues. No one's going to deny that. But how those issues are resolved and how quick and easily is like I said before, not my fault versus, well, okay, if this happens, it's going to damage my pipes and whatever it is. How can we prevent it from happening? Let's have a conversation, have a quick chat, and that might be just all that it takes.
Yeah, that really does reduce the risk of a contract builder if you're working with a builder where they're doing these coordination meetings, or if you're always working for the same builder and they're using the same trades, then you having that conversation to know what's in your scope, not in your scope, how the other subcontractors will be working, that will definitely reduce your risk, which means that you might not have to negotiate as aggressively with the contract. So definitely something to think about. On this slide is the essential elements of a contract. I get a lot of phone calls where someone will say, I haven't been paid by a builder, but we don't have a contract, which doesn't happen. If you're working on site, a contract exists in some shape or form. It's just not clear the terms and conditions of that contract. So a contract is formed when there is offer and acceptance, consideration, intention to create legal relations, and certainty. To boil it all down, basically when it's clear that you're agreeing to do X works for X dollars, that could be a contract. So I'll go through, the next slide has the case study. So I'll just, because this happens all the time. So what will happen is you'll send through your quote to the builder, and then sometimes you'll be asked to go to site straight away. And it's clear that they're accepting your price, but the terms and conditions are unclear. If you send a builder your quote and then you start on site, then you're trading on the terms and conditions on your quote. However, if you send your quote and then the builder sends you a draft subcontract and you think, oh, I don't like some of these clauses, so I'm just not going to sign it, I'm just going to start on site. But by conduct, you have probably accepted the terms and conditions of that subcontract. And the reason is, there's a few reasons. Number one, most draft contracts will have under the commencement clause, this contract commences on the earlier of the subcontractor starting works on site or execution signing of this subcontract. So the minute you step on site, you have by conduct accepted the terms and conditions of the contract. The other very common clause that you see in subcontracts is an entire agreement clause. So entire agreement clause, it means that the entire agreement between the subby and the builder is contained in that contract. And it means that all other things such as the quote, previous negotiations, discussions, they all fall away and the entire agreement is in that contract. So you might think, well, my quote excluded this. Well, if it isn't transferred to the contract, it doesn't matter. Most subcontracts include an entire agreement clause. So
that might be a bit of a surprise to a lot of these guys.
Yeah, I think
I guess I've heard this one, even as a builder, we've experienced it lately on site.
I didn't quote for that.
Or I didn't sign a contract and I don't have to do it. And you're like, you accepted the purchase order and you come on site. So it doesn't mean you can just legally walk away from anything. There is always repercussions. And this is where the knowledge is the key.
Yes. Yeah, I think a lot of people think once they sign a contract, they feel like they're safe. They feel like, oh, well, I'm going to get paid this contract amount and I've been awarded this contract, they can't give it to someone. But when you sign the contract, you actually sign yourself up to heaps of liability.
But don't be too scared. Obviously, you understand to a degree that you're always signing on to a liability.
Yeah.
It's just more about assessing and being aware of what they actually sign up for.
Yeah, exactly. But a better situation is if you actually start on site after you send your quote, because then at least the terms and conditions of that contract is your quote. So, and you'd hope that your quote only includes what you've allowed for. So at the tender stage, we were talking before about when you negotiate these contracts and your responsibility. At the tender stage, you'd want to bring your tender interview questionnaire, so your checklist of what you should be negotiating, but you'd also want to ask the builder for a draft copy of the scope of works and also their blank subcontract, so you can start to see what does the builder want to sign me up to. So you're not wasting all that time tendering and then suddenly you're taking on an exorbitant amount of risk and there's no opportunity to try to negotiate that risk. So let's break down the typical plumbing or construction contract. You get that 50 or 100-page document, sometimes 200-page document, and it's a lot to look at. All subcontracts are pretty much the same. They'll have the formal instrument of agreement, which is that signing page. So that's how you formally enter into that contract. There's nothing to it really, just you're signing it. What you might want to check with a formal instrument of agreement is what's the exact name of the party and the correct ABN and ACN, because it happens so much in construction that someone's got a, let's say, Builder Proprietary Limited, and they've got Builder brackets Vic Proprietary Limited, and then Builder Group Proprietary Limited. So you want to make sure that you are contracting with the exact entity that you think you're contracting with, because if there's a payment dispute afterwards, you can only recover from the exact entity that you engage with. So that's on the formal instrument of agreement.
And some of these builders are getting a little bit crafty.
Crafty with different names.
With different names and different legal entities. And unfortunately, it's up to you guys as well to do a bit of research in the background and to check it as well. So just something to think about. Yes.
The general conditions of contract is, that small writing that you see, there's quite a lot of pages, and that will go through the terms and conditions of the subcontract. And that's where you'll see the clauses about site conditions, you'll see the clauses about variations, you'll see the clauses about extension of time and liquidated damages. And that's the general conditions of contract that usually a builder always trades with all their subcontractors on, no matter what project. So it's a very generic and general terms. The subcontract particulars is usually a one-page document. It's usually written like a table form. So it says invoice date, 25th day of the month, payment terms, 30 days from the end of the month, or whatever it is. The subcontract particulars is a project-specific, subcontract-specific summary of the contract. Special conditions. That's when you're negotiating with the builder, all the amendments that you ask for should be contained in the special conditions, because special conditions will supersede everything in the contract. So if there's an inconsistency between the scope of works, for example, access equipment is included in your scope of works, but access equipment is not included, it's not included in scope of works, but it's included in the general conditions of contract. If you put in the special conditions, all access equipment is to be provided by the builder, then it's clear that it sits, that the builder is supposed to provide access equipment. So that's how special conditions work. It's all the amendments you want to the subcontract. The scope of works. I think most people are pretty familiar with the scope of works. It's it should be, you should match it to your quote. And in the next slide, we'll talk about scope of works in a bit more detail. Some other things that you see in a construction contract are the construction program, the drawing register, the deed of release, and these are all usually schedules at the back of the contract. So that's the breakdown of the scary 100-page, 200-page document. So the scope of works. The scope of works, you should match it to your quote. So generally your quote will list everything you include. So it's usually like say 1, 2, 3, 4, 5, everything that you're allowing for items of work. But the scope of works is written in the opposite way. It's generally written, the most inclusive way is to say the subcontractor will design, supply and install all plumbing works in accordance with the drawing register, including but not limited to, and I'll start listing all the items of work. And a lot of people start crossing out a few items of work that they haven't allowed for. But those are just examples of the work. That opening line says that everything is included in your scope of works. And so the only way to exclude things is to specifically write, okay, exclusions, and then say, I have not allowed for this, have not allowed for lagging, have not allowed for everything. So that's how you match your scope of works with your quote. So we'll go through some examples of bad contract clauses, and because we're running out of time, what I'll do is just go through one or two here and there. So liquidated damages. What do you hear from on the construction site? What does everyone think? How do liquidated damages work?
Oh, it's pretty easy. It's just the second I've finished, then the job's done, right? At the end of it, then I'm not liable for anything after that.
And I think a lot of subbies also think that if they've caused a delay, they're liable for liquidated damages. And if they haven't caused a delay, they're not liable for liquidated damages. But liquidated damages, how contracts work, it's a notification provision. So for example, if your practical completion date, your PC was today, the 18th of May, 2021, and the builder has delayed you all of January and February, you are still liable for liquidated damages unless you issue an extension of time notice. And usually these times...
But it's not me. They delayed me, right?
But how liquidated damage works is that you must notify the builder. You must notify the builder that you have been delayed because of his actions. It's almost like he doesn't know that, and it could be true. I mean, there's so many subcontractors on a site. He's basically saying, I don't know that I'm delaying you unless you tell me. So I'm still thinking that you'll finish on the 18th of May, 2021, unless you tell me that you won't. So the only way to move that immovable PC date is an extension of time notice. And they usually have strict time bars. They usually say, you must issue an EOT within 3 days from the delay event or 5 days. So how we manage this, we try to cap the quantum, cap it to 10% of your contract sum or whatever it may be. We'll just skip through. This is Variation clauses, you probably just need to maybe update the variation notices. So instead of 3 days, you might want to extend it to be provided in 5 business days. So you have a week to provide notification of variations. So what you should do is avoid the contract sitting in the bottom of your drawer, in the bottom drawer. So understand the risks and obligations of the contract so you can either try to negotiate it, price it, or when you sign on to it, manage the risk. And those are some of the issues that we come across. I'll just make sure that there's enough time for questions. So some of the issues to consider, we spoke about design and construct liability before, out of sequence costs, delay costs, those kind of things. And we'll just quickly go through this case study. So we were acting for a plumber and a payment dispute arose. Is that my opening line of every sentence? A payment dispute arose. I guess that always happens. Basically, this plumber was working on a site and the developer had some money problems. I'm not sure if they went insolvent or they just put the project on hold while they were negotiating restructure or something to do with the developer wanting to stop works. And so the builder says to the subcontractor, stop works as well. And because they didn't know when the works were going to continue, obviously the plumber wanted to be paid for the works that they'd put on the site, but they could not agree on the value of works. And how you can try to avoid some of these issues is to include a progress claim breakdown. So like a payment schedule. So you might have, say, for this stage, the value of this work. For this stage, the value of this work. And you should make it match what it really costs you as much as you can. Because if you front load it too much, then you might have some issues with, I don't know, they take out a portion of your work. So if you put it at the end, you might have some issues cash flow. So you want to have that breakdown. So most contracts will be written where the variation clause gives the builder unfettered discretion. So basically unlimited discretion to either increase or decrease your scope of works. So you want to make sure, if you want to make sure that they can't just take out, well, this part of your contract because it looks profitable or, issues like that. But, this happens quite a lot where, someone runs out of money, you have to stop works, but the builder's still solvent. So he wants to pay you, but you might not agree on the value of works. But there can be other situations where they might purposely take out a section of your work. So you want to make sure that the valuation is clear. So this is just a summary. Basically, if you understand your legal obligations and you understand the builder's legal obligations, you understand how everything interacts on that site, you're more likely to avoid a dispute.
And again, it's opening that dialogue. It's having the conversation needed. It's understanding the risk. It's reviewing the contract. It's, spreading the word down to your team as well at the exact same time. So if you guys can get your head around the way the industry is right now, you're going to avoid a lot of pain in the future. And we, even being builders ourselves, we want to see companies be successful. We want to see great trades develop their companies, good companies be solvent, doing great jobs, making sure that their guys are doing the great jobs and teaching the next generation how to do the industry properly. Now, we've gone through massive transformations in the last 10, 15 years in the industry. You can imagine, the whole apartment boom, the whole construction boom that's been going on. There's been a lot of, updates and a lot of changes in the construction code. There's been a lot of changes in the availability of staff. There's been a lot of changes, and everyone's been trying to shuffle and readjust and just throw a pandemic into it at the end of it, just to just for a laugh almost, just to see how good.
When things are getting really bad.
Things are getting really bad. It got a little bit worse, and then now we're going to go through another boom phase. So we don't think that we don't feel your pain. We understand very well because we are very involved in the construction industry, and we can understand that you guys are having a lot of anxieties and a lot of things that happened maybe even 5 years ago right now are starting to creep up or becoming an issue for you guys. But don't feel like you're alone. Don't feel like you got nowhere to go. Don't feel like, it's the end all be all. Just come and get some advice. Come have a chat to us. There are people out there wanting to help you and to clarify things, and some lessons will be learned as well. But as long as you guys are doing well and thriving, we want to see your businesses grow, and even, develop a whole bunch of generation of really good professionals, because then it all sort of tends to flow a lot better. Regulations are brought in for a reason to try and curb some of the issues that are happening. And sometimes the policing isn't done very well, and it takes a long time to implement, which is what we're sort of seeing with the cladding and other issues in construction. And the responsibilities have to be shared sometimes, especially the costs. But yeah,
I think that's some of the disadvantage with between the builders and the subcontractors when a dispute arises. It's the fact that the builders are managing the contract from the start. They're presenting the contract, and then they're having the contract administrators who are very well versed in the contract, administering the contract, while the subcontractors, they're spending all their time and effort in, being subcontractors, doing the best work possible, but not focusing on the contracts and understanding the paperwork. And when the payment dispute arises, it doesn't matter. It doesn't matter if you're the best tradie in terms of workmanship out there. This is still, it still affects your business. And even if it's not a payment dispute, it could still be 2 years down the track where there's some issues, whether it be actual defects or allegations of defects. It all kind of comes back to, well, what did you sign up to? And so I think a lot of subcontractors, especially when they're on site, majority of the time, they can feel a bit overwhelmed, and almost, I don't have time, I just need to sign up the contract, need to get that revenue in, and then go back to managing.
I'll deal with it later.
Yeah, I'll deal with it later.
It's chasing your tail.
But then this stuff ends up being more costly or more of a headache and than it really needed to be. So I guess I'll open up this dialogue. So.
Yeah. And it's really about education, right? So you guys need to understand that you're constantly learning and constantly evolving. And as sort of Pink said it before, you might be really amazing plumbers. You might do the job really well, and that's great. But also at the exact same time, you will come across guys that aren't so great, and maybe builders that aren't as versed, or maybe they've set the contract up that it looks dodgy as hell. We've seen some contracts that's like, wow, they've just literally written it to
just push everything onto the
subbie and take no responsibility. And you can see a massive legal team behind it. It's almost not even a construction company, more like
just running contracts.
Contract administrators in the background. And then this is where you guys now have to start learning about, sometimes saying no is actually really good, but it's also just highly getting the education, or even hiring somebody to professionally look at what you're getting yourself into. So,
and it doesn't always have to be no to that subcontract. It might be, yes, I'll do the contract, but I'm not going to agree to that clause, or I'll agree to that clause, but limited to this amount of risk. So it's definitely not as black and white as yes or no.
And there might be some anxiety in doing that, actually.
Exactly, but until a lot of times
you'd be pleasantly surprised.
Yeah, even some of the builders that you think may be the very immovable, you'd be surprised. You just try negotiating certain things, try negotiating a retention, try negotiating some of your defect clauses or defect liability periods, and you might find that they say yes. So, well, thanks very much for your time. I think that's all. We have time for today.
Our information's up on there.
Yes.
You guys can obviously call us or have a chat and send some questions through if you guys need it quickly answered. But we also offer a lot of training for companies that want to maybe get educated for the whole team.
Oh, it looks like someone's got a question.
Oh.
We thought that no one had any questions.
And then there it comes.
You do have one question there, and as they said, feel free to chuck in any other questions as well. Also, I just wanted to say as well, first of all, thank you. But I also wanted to say, if you feel like there should be a part 2 of this, or there's some big thing that we've missed, there's a lot of things to get through today. If there's a certain area that you maybe thought we could tackle at a different time, feel free to chuck that in the Q&A as well, and we can sort of go through that at a later point if we don't have the time for today as well. But yeah, Ping, I'll hand over to you for your question.
I'm going to read that. Answer it.
My eyesight's really not good.
Okay.
You've got the laser eyes.
The laser eyes. Some of our builders give us, sorry, this is from someone from the audience. Some of our builders give us a letter of intent so that we will commence works and not delay the project. We don't get the legal contract until we've already worked on site for a number of weeks. This makes it more challenging to negotiate the terms of the contract to minimize our risk. What would be your advice in these situations? So this is actually a fantastic position for the subcontractor. Just most subcontractors don't realize this. So if the builder has directed the subcontractor to start on site and there's been no draft contract or no terms and conditions, subject to if there's terms and conditions in the letter of intent. Basically, it's offer. There's the quote. So a plumber has submitted their quote with their terms and conditions on the back. And if you got us to draft them, they would be awesome terms and conditions.
And we can do that too as well for you guys.
So you're sending in your quote with awesome terms and conditions that are favorable for you, the best possible terms and conditions. And if the builder hasn't sent in a subcontract, he's accepting with the letter of intent your terms and conditions. If the letter of intent, letter of intents usually have the price, and they might say, we will enter into a subcontract shortly, but it doesn't actually have any other terms and conditions other than the price. Then in that situation, you're trading on your quote and whatever price is in the letter of intent. Hopefully it coincides with your quote. And yes, you're on site, so you want to get paid for works, but they might tell you, we're not going to process your first progress claim until you sign up to a contract. However, and we didn't get much time to touch on this, but legally, and especially using things like security of payments, they have to pay you. They have to pay you on the payment terms on your quote. They can't withhold payment until you enter into a subcontract. So you should actually be in the best position to negotiate because they need you on that site. They've already agreed to enter into a contract with you on your terms and conditions, but they're probably commercially pressuring you to enter into a subcontract before they process payment. So I guess knowing that they're legally bound to your terms and conditions hopefully helps you negotiate with the builder, and hopefully the cash flow is not too much of an issue and you can use that to negotiate the terms of the contract.
And security payments is something that we are always over. So you guys should really familiarize yourselves with.
We're very passionate about security.
Yeah, it's a complete separate court system it's just for construction. So you guys have to understand how that works. That's a really critical issue. It's generally that you guys get paid first and then some issues can be resolved later on. But it's mainly about the cash flowing through the industry, making sure that they're not being leveraged against from the builder's perspective against the contractor because they're holding your money. So you really should get on top of that. And
yeah, so in this situation that someone from the audience posted the question, legally you're in a position where they need to come to the table to negotiate with you. Obviously, you don't want to get into a payment dispute at the start of the project, but hopefully that helps you to say, hey, I don't want to agree to this. We never talked about me taking on the design responsibility or whatever it may be. And you can use that to get to the position that you want to. But yeah, definitely.
hopefully that answered your question.
Yeah, hopefully that.
Perfect. All right, we might finish it up there just because we have hit 3, but I'll be, as I said at the start, I'll send everyone through an email with the recording and the slides. So I'll also put in Level Playing Field's contact details into that as well. So they're happy to answer any extra questions you have. If you have any questions for us at Master Plumbers, feel free to reply to that one as well. But thank you, Boyoung Ping. Thank you very much for your time today.
Thanks, guys. Thanks, everyone.
Greatly appreciate it.
Great.
Thank you so much.
Take care.
Thanks.
Bye.